Okay, so we're Group 20, and our topic was about aligning Maryland's environmental standing laws with federal standards.
So, first, for an introduction in some context, Maryland faces a large number of environmental and climate concerns, and one of these is a significant air pollution problem. The term legal standing determines who is able to bring lawsuits to enforce environmental protection, and currently, federal standing laws allow any individual or organization who demonstrates injury in fact, causation, and readdressability to sue. However, in Maryland, individuals need to prove that they are uniquely harmed, which makes its laws really restrictive and one of the most restrictive out of all of the US states. So, some ongoing legal barriers currently is the unique harm requirement, which I briefly mentioned. Maryland requires plaintiffs to prove that they are uniquely affected, which excludes lawsuits that impact entire communities. For instance, if there was an air pollution problem that impacted an entire neighborhood, Maryland would say that individuals are not able to sue because they haven't proved that it uniquely affects them as an individual. Second is narrow causes of action. Maryland's Environment article lacks broad citizen suit provisions, which basically poses huge amounts of barriers to ordinary individuals who want to sue, so they're only able to bring lawsuits in very specific instances. Next is the taxpayer standing restriction. Maryland demands proof that plaintiffs are taxpayers, the official acted illegally, and that the lawsuit also benefits other taxpayers. And lastly, are procedural hurdles. So there are a number of these. Some of them are pre-suit notice requirements, the state's exclusive enforcement rights, which means they're the only ones who can enforce it, and also potentially dismissal for duplicative lawsuits. And all of these make the process a lot longer and harder.
Legislative progress. So in 2024, Maryland passed the Clean
Toby,
Water
speak a
Act.
little louder.
Okay. It allows individuals, nonprofits, and associations to sue if they meet federal injury standards. This act expanded the scope to cover non-tidal wetlands and small streams. Before suing, there's a required 60-day notice to the MDE or the Maryland Department of Environment, as well as notices to the Attorney General, violators, and local government. Also, citizens can intervene in state-led cases or invite the state to join theirs. Some remedies include injunctions like warnings and civil penalties like fines. However, if Maryland is diligently enforcing the law, then private suits are blocked. The idea is to avoid duplicate legal actions when the state is already handling the problem. Also, this law has a very narrow focus and it doesn't cover things like air pollution or toxic waste. And now I'm going to talk about some environmental standings in other states. So in California, Massachusetts, New York, and Washington, there are broader standing laws as compared to Maryland. In California, any person can challenge environmental impacts, while in Washington, anyone showing a significant impact can sue. Furthermore, in Massachusetts, people and associations can sue for things like aesthetic, recreational, or conservation injuries, making it easier to bring forth cases. And finally, in New York lets anyone with an affected interest to participate in lawsuits, which increases public involvement in environmental decisions. As compared to Maryland, these states have more flexible standing laws that allow greater public involvement in environmental issues.
Next, for policy recommendations. The first step to aligning Maryland's environmental standing laws with federal standards would be to broaden standing scope. We would be doing this by expanding coverage to more environmental related harms. As the policy seen here, HB 1101 is only water related. This would cover air pollution, hazardous and toxic waste, as well as brownfield runoff and land degradation. The first step would be to eliminate the unique harm requirement. Basically, we would remove the special aggrievement rule that requires plaintiffs to show unique harm and adopt the federal injury in fact standard. Although the federal injury in fact standard still requires plaintiffs to show that they've been properly or kind of concretely harmed by these environmental sort of problems, they don't need the same sort of, they're not as constricted as they don't need to prove that they themselves are uniquely affected by this harm. This would also amend the Maryland Common Law and Environmental Article to align with other modern environmental litigation standards that other states have. As for feasibility, we determine feasibility by how plausible it is to sort of create these changes. As for broadening standing scope, this has medium feasibility as there is strong stakeholder support, but it requires increased resources and may raise administrative costs. As for eliminating the unique harm requirement, this has high feasibility and is relatively simple to do as it aligns well with legal standards and existing reform momentum as well as has manageable administrative impacts. Thank you.
Thank you. And yeah, can you close the screen? Yeah, thank you. I think it's pretty comprehensive. I like the way you present, compare what you have and some existing law has been covered, make that suggestion. And the great summary, I really love it. Thank you, Selena, Sophie, and Alison.